Companies Act, Section 215, Prohibition on appointment of a firm, body corporate, or association as inspector. The Companies Act, 2013, under Section 215, lays down a specific restriction with regard to who can be appointed as an inspector for the purpose of investigating the affairs of a company. This provision is part of the broader legal framework governing investigations under Chapter 14 of the Act and reinforces the integrity and accountability of the investigation process. Purpose of the provision. The central objective of Section 215 is to ensure that individuals appointed to carry out sensitive investigations into the affairs of a company are natural persons, that is, actual human beings who can be held directly accountable for their conduct, performance, and impartiality during the investigation process. Given that investigations often involve access to confidential business records, sensitive financial data, and interviews with key personnel, it is essential that inspectors possess both the requisite qualifications and a clear line of accountability. This cannot be adequately ensured when the role is assigned to a non-human legal entity such as a partnership firm, a company, or an association of persons. Key prohibition. Under Section 215, no firm, body corporate, or other association shall be appointed as an inspector. This single-line provision carries significant weight and mandates the following. A. Firms, entities such as partnerships or limited liability partnerships, LLPs, are expressly barred from being appointed as inspectors. While these may consist of professionals with investigative expertise, their appointment as a collective body is disallowed under this section. B. Bodies corporate. This includes companies registered under the Companies Act or under any other law. Regardless of their business or professional standing, bodies corporate cannot act as inspectors under the Act. C. Associations. Any unregistered or registered associations or groups of persons acting collectively are also disqualified from being appointed as inspectors. Implications. The section requires that only individuals, specifically natural persons with appropriate credentials and experience, may be appointed by the central government or other competent authority as inspectors under the investigative provisions of the Act, such as under Sections 210, 212, or 213. This ensures that investigations are carried out by identified, qualified professionals who can be held personally responsible for their findings and conduct. It removes any ambiguity or dilution of liability that might arise if legal entities or associations were allowed to act as inspectors. Underlying principles. Section 215 reinforces several key principles of regulatory oversight. A. Accountability. By restricting the role of inspector to individuals, the provision ensures clear accountability for the conduct of investigations. B. Transparency and trust. It promotes public and stakeholder confidence in the investigative process, knowing that it is handled by designated individuals under the supervision of the central government. C. Legal certainty. The provision eliminates potential legal complications that could arise from collective or delegated responsibilities within a firm or company acting as inspector. For more details, contact us.